It's not listed. On 13th,
No. Not like that. How can it be?
then the next Monday, 20th day, next Monday,
Hearing matter.
hearing that. In
What
last
is-
order, it was stated that it is to be listed in the month of February.
I don't know. But what is to be done? I don't know. It's not like hearing matters in criminal cases. It's not a cakewalk. You know, it takes a lot of time.
Bail was not there. He's behind the
Bail.
bar guard.
What is the matter about?
His conviction under section 6 of
POCSO Act.
Yes, madam.
POCSO Act is appeal task. You know that. Okay. 14.
Put him on 20th, 20.
20.
20.
No, not on a Monday. Monday is not a hearing date.
14. 14.
Made vigilance. My lord, if your lordship would kindly have a look at order dated, my lord, 6/1/23.
Before you start,
Yes.
Mr. Chaudhary,
Yes,
this Mr. Mr. Chakrabarti. He was, no, she wanted some time to obtain instruction
yes,
as to whether the Union of India should be pleaded as a party.
yes.
Now, where is she?
I'm here.
Oh, yeah.
I'm assisting. Sir.
Okay, yeah.
So, my lord, Union of India, as such, my lord, we have no claim against Union of India. in
But
this
they're
case.
supposed to give some approval.
No, my lord, my lord, that is the making of the government of Mizoram. My lord, if they were so conscious of that, then they should have pointed out on that day itself. When this order was passed, then they should have said that. My lord, you kindly see, already 1 year is gone. Now, they're verge of losing their second year. They're adamant that they will not give the admission. I don't think Lordship will permit this to happen. There's an order of the court, and my lord, the learned Advocate General appeared on that day. If virtually, my lord, considered, he said government is considering. Having regard to all these things, my lord, this order was passed.
Page.
Page number 6/1/23, my lord. If your lordship will kindly come to page, second page, my lord.
Yes.
Sentence starting it is not in dispute that the classes of MBBS course for the current session has already commenced, and there are 3 vacancies available at present. This information that there are 3 vacancies, it was given by the state. Therefore, if the 3 out of the 5 petitioners are accommodated against those seats, no prejudice would be caused to either side. On the contrary, if seats remain vacant and eventually petitioners succeed in the repetition, and in that event, enormous prejudice would be caused to the petitioner. Therefore, having regard to the peculiar facts and circumstances of the case, and by adopting a balanced approach where of the considered opinion that present is a fit case where an interim order is required to be passed, it is the undisputed position, in fact, that marks obtained by the 5 petitioners in the NEET are so and so, so and so, so and so. Since there are only 3 seats vacant, the top 3 candidates would obviously be entitled for consideration at this stage. Since all the respondents are represented, no formal notice is required to be sent. The parties have exchanged their pleading. Therefore, an attempt would be made to dispose of the petition at that stage of admission. As an interim measure, it is hereby provided that petitioners Monita Dewan, Chakma, Renki so and Harshika Chakma be provisionally admitted and permitted to attend the classes in MBBS course, which should, however, be subject to further orders that may be passed in this petition. Well, in the meantime, an IA has been filed by a particular candidate, my lord, who claims that he has secured more marks than my lord Harishika Sakma. To that extent, my lord, we are not contesting that claim. If she is getting higher marks, then he should naturally get it. So that we are not opposing. At least, my lord, the first 2 should get, my lord. My lord, this is not a case which is coming for the first time. This matter is pending for the almost, my lord, 2 years.
Yeah. Yes.
My lord, once the order was passed by this court on 6/1/2023, my lord,
Yes,
6/1/2000, which my learned friend has pointed out,
yes,
and there is an order from this court to grant provisional admission
yes,
to 3 out of the 5 petitioners.
yes.
And accordingly, on 23, we were not aware of this situation because we informed the order of the court to the government. That this
You
is the
informed
order that
the,
has been passed.
you informed this order.
Yes,
6-1.
this order of the government, that this is what the court has passed the order.
Yes,
Now, on this government, the government of Mizoram has sent to the ZMC about the order that was passed by this honorable court, and this is the order which has been passed. ZMC has written back to the government, my lord, stating that there has to be some approval from the government of India. So, last date of the admission was over on 29th of December 2022. 29th of December 2022. So if any seats is to be allotted, it is Government of India permission is required. So we written 2 letters on 23/1/2022.
just a minute. So the
On
last date of admission was 29/12.
29/12/2022. Order is passed on 6/1/2023.
And when did you write a letter?
I wrote a letter 31/2023.
31,
2001/2023.
13/1,
30.
2023
to
the Government of India.
Yes, Government of India. Again on 14/2023, we again has given a reminder.
14/2.
14/2023. But all this situation will be solved if they come forward and say that we have no objection, my lord, because ultimately their approval is required. Now there is a change of a law, my lord, which my learned friend will definitely say it's a covered case by a division bench judgment where it was set. They have set aside the earlier rules. Now that judgment, the division bench have relied on particular judgment of an apex court and they passed an order. So E.V. Chennai's case again, my lord, it has been that E.V. Chennai's case is by 5 judges. So this 2028 SCC 1, my lord, Devinder Singh case, my lord, that again, my lord, there's a 5 judges. So they have referred this particular matter E.V. Chennai to larger bench, whether there can be any sub-classification or not. So this is
anyway,
again, my lord,
but as on date, this order is still holding the field.
yes. But no, my lord, the situation, but then I have to refer to the judgment of the how, my lord, they have referred, and there is a difference of opinion of the 5 judges. Same, my lord, 5 judges. So this is, my lord, has to look into that perspective.
Okay, another
It
aspect.
is not a covered case, my lord. now.
Okay, another aspect of the matter is that the Government of India has to give approval now.
Yes.
Well, there is
This is-
nothing
I-
like
I
it.
have a- Absolutely,
from-
there is a
I don't
approval.
know. They could have filed an affidavit, my lord. We are in March.
No,
This
no.
order was passed on January.
Let us be clear, because I do not know. You all know,
No,
I
my
don't
lord,
know.
my lord, each day is to our detriment, my lord. Also kindly appreciate, we have lost all, there is an order of this honorable court in the last year's proceedings. There is a contempt proceeding. Now there is an order of January 6th. Till date, they are not complying with. Lordships will not permit this. Otherwise, my lord, what impression people will carry about the system, my lord? Lordship will not permit state of Mizoram to behave like this, my lord. It's a very serious matter, my lord. If an order of the court after hearing the Advocate General order is passed and the state does not comply with it, it's very unfortunate, my lord. My learned friend himself virtually considered. He said the matter is being looked into. We waited, the court waited on the based on that. On subsequent date, this order was passed.
No, I know,
After all,
my
he is
lord.
a student.
No, I
Where
also
she will go, my
understand.
lord?
I also understand, my lord. Students, my lord, careers is involved, my lord. But ZMC cannot act. That's the whole problem, my lord. They have written
Show
that.
me why they cannot act.
My
when
lord,
the-
can you see this, my lord? It was.
My lord, Government of India normally does not interfere in these matters, my lord. There's nothing to call, at best, MCI could be a relevant, they may have some say in the matter. How can in a medical admission matter, Government of India will have any say, my lord? Which is law, which is the law which requires Government of India's approval?
My lord, it is through the Director General of Health Services, my lord. Government of India.
Where? Which one?
My lord will kindly see the Zoram Medical College letter
Yes,
and kindly see the enclosed one, 21/12/2022. 21/12/2022.
yes.
And kindly see on the last, my lord, kindly note the last date. Last date of joining admission for so and so would be conducted by the state is 28th of December 2022. Now, that was extended by 1 day, that is next page, my lord. 28/12/2022. If necessary, we'll within 1 week we'll file this affidavit with all the records and everything. All this will annex it.
No, but where does it say that the government of India is,
First page, my lord.
what does it say?
Yes.
Since the mop-up round of UG Council.
First, 27th of January, in reference to your letter mentioned above,
Yeah.
concerning the interim order of the Honorable Guwahati, this is for an informant. The last date of admission for state counseling for MBBS 2020 batch was 28th of December 2022. As per Directorate General of Health Service, Government of India notice dated so and so, which was extended till 5 p.m. of 29th of December 2022. White notice dated 28/12/2022. As the last date of admission for state is over as per the notice from Government of India, insofar as we know, Zoram Medical College may not admit any MBBS student without the explicit permission from the central government. Your guidance in this matter will be most appreciated. Zoram Medical was started MBBS classes from 15 November 2022. Admission was going till 27th of December 2022. Moreover, as mandated by the National Medical Commission, list of 96 students along with the details has been sent to NMC in soft and hard copy format. So this is for kind of information. So accordingly, we have written on basis of this. On 30th of January, we have written immediately to the Assistant Director of, my lord, will kindly notice this.
My lord, can I just explain the position, my lord?
But
Now,
just your lordship will look into this letter first. I have to inform you that Honorable Guwahati High Court in order in WPC directed that 3 students petition, namely so and so, Zoram Medical College, where 3 seats for the state course which have already been allocated have become vacant due to vacation of the state seat by allotee. Director ZMC was approached for compliance with the state order, but director informed us in the letter under reference number so and so that since the period of admission of the state course has already been closed, the college may not admit any without the explicit permission of central government. Copies of the honorable court's order and letter are attached. Now the copy of honorable court is forwarded for your kind information and necessary action. Again on 14 we have written. It's not that we have not taken steps, my lord. 9 February 2000. If this approval is accorded, absolutely no problem. Immediately we informed them.
my lord, can I come in, my lord? There are states cases 29/12.
What
was
is the
last-
case all about?
No, no, I'll just come in. Lots
Yeah.
of kindly appreciate. The state's perspective now is that 29/12 was the last day. Therefore, now admission cannot be given. That is the case
Yeah.
in sum and substance.
Correct.
Look, this is this normal process. In the normal process, the state authority cannot. Now, there's a court's order. Lordship knows, my lord. Constitution has given the court's order in a different, kept in different pedestal. When High Court passes an order, Supreme Court passes an order, is not required. I'll give you examples, my lord. For example, my lord, when High Court directs a CBI inquiry, then the state's concurrence is not required. When High Court passes an order, my lord, the Assembly did not pass the appropriation bill. To implement the High Court's order, if any money is required by the state to be spent, then my lord, appropriation bill is not required. These are one of the few instances. this is a provision regarding normal admission matters. In a case where a student has been arbitrarily refused the seat, the student comes to the court passes an order. How by what legal reasoning, my lord, those justifications will apply here,
No,
my
you
lord?
see, but if
And
the-
these are not all India quota seats.
no, but Mr. Council, one thing is, if the permission is to be accorded by the central government, and central government is not a party, then it causes a problem.
My lord, I have a specific submission. This is not the way, my lord, citizens' right can be played by the state. Now, because of the delay, my lord, if we lose seat this year also, then lordship will have to fix responsibility upon the officials of the government of Mizoram who are responsible for this. Lordship will keep that option open, my lord, and let central government obtain the instruction on this.
No, who's
So,
for
no,
the
lordship
central
will also
government?
make that observation, that in the event court comes to the country, allows the writ petition, and which is bound to be allowed because, my lord, it's a covered
No,
case.
but one thing, Mr. Council, one thing is
No,
on
my
the
lord,
last,
this is not the way, my
no,
lord.
on the last day,
No,
it
next-
was,
Next year. no.
on the last
But my
day,
lord, admission notification for the next year is already published.
that's what, now on the last day,
Hmm.
if you had made the submission,
Hmm.
on the last day, yeah, the submission made by the petitioner was that instructions, time was prayed for by the petitioner to obtain instructions whether Union of India should be implemented. If you had, if
No,
the
my lord.
petitioner had given this, if
No,
you
my lord,
given
see-
your submission on the last day,
My
you
lord,
could have implemented by then.
No, no, 226 proceeding is not a civil suit. Lordship,
Correct.
we need not go by any formality. Lordship can straight away ask the CGSC to obtain the instruction.
That's what we're going to do.
And Lordship will fix it in the, within a week, my lord, they will have the instruction.
Who is the CGC out here? Okay, right one. Right.
I'll inform him, my lord.
Heard Mr. K. Yes, anything to say?
Lordship, actually, I have filed IA to
Ah.
ask for the already expired, but
Which IA? Which IA?
My lord, Lordship will keep that IA pending because if we cannot be admitted, he also cannot be admitted.
Correct.
My
No,
lord,
no.
he-
No,
my
no,
lord-
but we'll just record this. Yes,
my
which
lord,
IA is
he
it?
admitted that the IA, we don't
Just a
object the
minute.
IA.
Which IA is it?
One is my lord, 468 and 469.
468 and 469.
It's very
Oh,
simple IA, my
What
lord.
is your case?
My case is that, my lord, by
You have got better
inadvertence, by
marks.
mistake,
Ah.
a seat was given, admission was allotted to those who did very got lesser mark.
Then you.
So, my lord, he admitted that petitioner counsel also. my
So
lord,
who has, just a minute, who has got lesser marks than you?
My lord, if
The
you
third
kindly
one.
see- if
Third
you-
one.
Harshita.
Harshika.
If you kindly see, my lord, my IA page number,
No, just tell me. I don't have to see. Just tell me.
yes. Harsika Chakma got 217.
So Harshika.
I got
Oh,
278.
it's okay. You just have to tell me the marks. So you got higher marks than Harshika.
Yes,
That's all.
yes.
Correct. Heard Mr. K. N. Chaudhary, learned senior counsel for the petitioners. Also heard Mr. D. Das, learned additional lady for the state of Mizoram. First of all, also heard Mr. J.C. Lanusama, learned counsel for the applicants in IA Civil 468/2023 and 469/2023. The petitioner's grievance is that despite the order dated 6/1/2023, directing that the writ petitioners, that is number one, Monita Diwan Chakma, number two, Renki Tong Changya, and three, Harshika Chakma. That is at this thing, in the order dated 1/6/1/23, last page. Should be provisionally admitted and permitted to attend the classes in the MBBS course in the Zoram Medical College. Mr. Didas the AG Mizoram, on the other hand, submits that the order dated 6/1/2023 issued by this court was communicated to the Government of India by letters dated 30/1/2023 and 14/2/2023.
9/2/2020.
Huh?
9/2/2020.
31/2023
9/2/2020.
and 9/2/2023
Correct. 2020.
instead of 14. Okay, 9/2/2023. To give approval / permission for allowing the above three writ petitioners to be provisionally admitted. However, no communication has been forthcoming from the Government of India. Next para. The case of the applicant in IS Civil 468/2023 and 469/2023 is to the effect that he has got higher marks than this is a lady or a Harshika is a lady or a male?
Lady,
As a girl.
Lady
lady.
against Harshika Chakma. Miss Harshika Chakma has got higher marks than Harshika Chakma, and as such, the applicant has got a better claim to be admitted than the said writ petitioner. Full stop. Next para. In view of the fact that there has been considerable delay on the part of the government of in which department, which ministry, who has to give the permission
Director General of Health Services.
in as much as in view of the fact that there has been considerable delay in taking a decision on the request made by the government of Mizoram to comply with the to give permission for filling up three vacancies in the MBBS course on provisional basis in terms of the order dated 6/1/2023, from the Directorate General of
General of Health Services, Government of India.
the Health Service, Government of India, This court deems it fit that the said party should be pleaded as respondent number 3. Full stop. Accordingly, the Directorate General of Health Services, Government of India, Ministry of Health and Family Welfare
Yes.
is pleaded as a respondent number 3.
My learned
Mr. K. Gogoi, CGC, accept notice on behalf of the respondent number 3. Petitioner and the petitioners and the respondents shall supply.
My lord will also make one thing clear, my lord, whether in respect of court order, there is a permission is required. Lordship will kindly.
Petitioner shall also supply copies of the writ petition and counter affidavits to the CGC within 2 days.
No, today itself.
Within today, within the course of the day. Within the course of the day. Full stop. Next para. Mr. K. Gogoi, CGC shall obtain instructions with regard to the letters dated 30/1/2023 and 9/2/2023 issued by the
Director, Joram Medical College.
no. Issued by the
Director PhD.
Huh?
Higher and technical education.
issued by the Director,
Higher and technical.
Higher and Technical Education,
Government.
Government of Mizoram, with regard to the provisional permission to be given for filling up 3 vacancies in the MBBS courses, for which the admissions had closed on 29/12/2022. Full stop. The CGC shall obtain instructions with regard to the said letters and the order dated 6/1/2023 passed by this court
My lord,
as to why the central government needs to give permission for filling up the
State
Three-
quota seats.
the state quota seats in Zora Medical College. uh, When there is an order already passed by this court.
Declare.
List the matter after.
My lord, let it be on 17th, my lord. They'll get up more than 8 days, my lord.
my lord, before that, my lord,
Just a minute, next para.
17th.
Before that, you're right. The above being said, comma, the further issue that will have to be considered by this court is whether the applicant who is alleged to have secured higher marks than Shri Harshika Chakma should not have a better claim to any vacant MBBS post.
On next step, lots of once.
my lord,
They are respondent number 7. Because
Subject to correction, my lord, the central government will be perhaps respond number 8 because I am appealing for respond number.
Okay,
3
make
to
it
7.
8 instead of 3, make
Oh,
it
that's a independent. I'm sorry, right? I'm
I am
sorry.
appealing for respond number 3 to 7. my lord.
8. Okay, make it 8, huh? Make it 8.
my lord, allow me to say in my respect of my eye, one important thing. Now, process has been already going on. So there is a chance that Harshika Chakmas may be allotted in the meantime. So my matters, it's simple matter, my lord, they are not claiming anymore.
On next step, the lords will consider his.
They are not claiming this seat anymore, my lord.
Huh?
Because there is the files in respect of everything pertains to Harshika Chakma now.
No, I've said it here. I've said it.
Well, it
that-
is not clear. There is a chance that they might give seats to Harshika Chakma in view of order.
Okay, just right. It is made clear that in the event the applicant in IA so and so is having is having better marks than Shri Harshika Chakma, the applicant should be considered, may have to be considered for admission to the vacancy instead of Harshika Chakma.
No, my lord.
That's all.
Applicant Isaac, that you say Isaac instead of Harshika. My lord, that mistake, my lord.
What mistake?
My lord, my appearance may be recorded for respond number 3 to 7.
Mr.
HK Das. my lord.
HK Das appears for turn number 3 to 7. Huh? This is the matter of 20th. Huh? Yes? A copy of this order. It will be uploaded. You print it out. Why do you want the separate? No need. Yes, Mr. Didas, anything else? Mr. Didas, anything else?
No, nothing.
17.
It's on 28th, your lordship.
20th.
Not 17th.
No.
20th.
Actually, I think you have to file your affidavit in the meantime. Yeah.
Meeting the company.
No, with regard to this
Oh,
government.
this one. We will find it.
Lordship, item number 4 is Lordship's reference preferred by the state of Assam. In case query, Mr. PJ Mahanta has been appointed as senior counsel in the matter. Lordship, actually, my friend Jahan has dealt with the matter.
Ah.
She has some personal difficulty today, Your Lordship, and we could not take consent from the other side because the list was the last hour list was published, my lord.
Huh?
She did not take consent, Lordship. We could not take consent from the other side. It's up to your Lordship. If your Lordship takes up the appeal first, then reference may be
It's
taken.
a date reference.
Date reference.
It's a date reference. Whether date reference will be heard first or appeal will be heard first. There is necessarily appeal will have, if appeal goes, everything goes. So in that case, appeal has to be heard first. But in that, if your lordship heard the date reference, then the state has to argue first. Because it is a reference by the state.
I don't know. What do you say?
As per, Malab, it has been a convention that in case of a that reference, it will hard fast.
That
So,
reference has to be heard first.
yes, but only other day, the matter was listed before court number 2, my lord Mr. Justice Singh. So I want to argue that my submission of that in case my appeal allowed, the reference will automatically go.
Ah.
So my lord said no, as it is the convention is being followed since long. Reference will be unless the conviction is confirmed, we will not hear on the point of your appeal.
That is also one of the.
Yeah, so if it is
and one handbag. Exhibit 2 is the seizure list, where Exhibit 2.1 is my signature. A pair of scissors and a knife were seized through Exhibit 3. Exhibit 3 is my signature. Police carried out an investigation. The negatives of the photo taken by police are not available. A lot of people gathered there. I identified the ring and the handset, which were seized by the police. My lord, according to him, he has identified the ring and the handset of the deceased wife to be of my wife. Police recovered those articles from Soleiman. The police arrested the accused and recovered the article from him the next day of the incident. Police recovered a Samsung handset with SIM number 8011187606 and the mobile handset of my wife from Soleiman. 2 extra batteries were also recovered. Rupees 5,205 was recovered from the accused. 1 pair of jeans and a green color shirt were also recovered. I put my signature on the seizure list. Exhibit 4 is the seizure list, where Exhibit 1 is my signature. Material Exhibit 1 and 2 are the 2 CDs. Now, my lord, I'm coming to the cross part. The building in which I stay is a 2-story one. I stay in the first floor. I have an Assam type guest house on the second floor. I have rented out 2 parts of my ground floor. 2 parts of the ground floor. Domestic helps usually visit my tenants. Families of 2 tenants, and I stay in that building. A road runs by the side of the building. Vehicle ply and people commute by the road. I have a plot behind that building, and a road runs behind that plot. It is a busy road. There is a market half a kilometer away from my building. There is no shop near my building. There are shops some 500 meters away. On the day of the incident, the girl and the mother were in the rented room. I do not know whether they were there at the time of the incident or not. At the time of the lodging, the Azahar, I did not mention the name of anybody. The accused used to visit my house frequently. I did not notice any valuable article missing from my house. My lord, this is very significant. He has specifically stated in his cross-examination, I did not notice any valuable article missing from my house. Police seized the articles mentioned in Exhibit 2 in my presence. The handset and the ring were not seized in my presence. My lord, because in examination in chief, he has stated that the police recovered those articles from Soleiman. Whereas in his cross-examination, he has stated the handset and the ring were not seized in his presence.
Correct. It did not say his
It
presence.
has
It
not
was told to him that.
Yes, because he has not gone into the residence of the accused. That is why he did not see him. But later on, police might have taken his signature on the
We'll see,
seizure.
that we'll see.
Yes, my lord. Police seized the article mentioned in Exhibit 2 in my presence. The handset and the rings were not seized in my presence. I do not know how my wife died. I have not seen the seized article in the court. I have seen the seized CD and the photographs in the court today. I'm not aware of the content of the CD. These are the deposition of PW. Now I'm coming to PW2, my lord. I know the Roman Borua and I knew his wife as well. I do not know the accused. Roman Borua's house is at a little distance away from my house. At first, Rumi Borua's friends, Mira Borua, informed me that some dacoit thieves had entered the house of the Rumi Borua. I was called upon there. I went to the place of occurrence. As I was the joint secretary of the housing, the information was given to me. I entered the house of the Rumi Borua. Since the entrance on the front side was closed, we entered the building by climbing the stairs. Going inside, I saw Rumi Borua lying dead with the blood overall. Pulu Sankakoti and I informed the police. Now, my lord, as per him, he and one Pulu Sankakoti, they have first to inform the police. Meanwhile, police arrived at the place of occurrence. We, the members of the committee, cooperated with the police. The police brought a sniffer dog. An executive magistrate also arrived there. In the meantime, Roman Borua arrived home. In the course of investigation, Roman Borua stated that he had suspicion on the person who had painted his house. Exhibit 2 is the seizure list, where Exhibit 2.2 is my signature. In Exhibit 3 and Exhibit 3.2 is my signature. Police examined me. Police found a knife at the place of occurrence. Roman Borwa said that the said knife did not belong to them. Now, my lord, I'm coming to the cross. The place of occurrence is about half a kilometer away from my house. Roman Borwa and I are the members of the same society. Meera Rani Datta called me over phone. Meera Rani Datta was the secretary of Mohila Samiti of the society. At the time of the incident, she was the secretary of Namgarh. She rang me up regarding the incident after 2:30 p.m. Well, this is the basic testimony of PW2, and I'm not going forward because I'm not very much relying on this particular PW. Now let us come to, my lord, PW3. PW3 has a relevance only to the extent that he has written the FIR, my lord. He is the one who has scribed. My lord, may directly come to page 17. I'm not reading the content of the page 16. Going there, I saw blood-smeared dead body of Rumi Borwa lying there. I also saw a pool of blood in the nearby room. We informed the police and the forensic laboratory. I had been at the place of occurrence till the time of handing over the dead body to the police. The police questioned me. I wrote the FIR and Roman Borwa put his signature therein. Exhibit 1-2 is my signature as a scribe of the SR. My lord, this is the main point regarding PW3.
So there's nothing, okay. I just
Nothing
wrote the FIR
He has simply
and
written the FIR.
PW one sided.
Yes, my lord. Now, my lord, PW4 is going to be little bit of relevancy because it is questionable in this case at what appropriate time the deceased person has died and at exactly what time the information of her death has been given to the police station. I know the accused present in the dock. The police arrested the accused person in connection with the murder of Rumi Borwa, and I have known him since then. The incident took place at Narengi Housing Colony on 22/12/2010. Around 4:30 p.m. on the day of the incident, my wife informed me over phone that someone has killed Rumi Borwa and that I should inform the police. I immediately informed Nunmati police station of the matter. I also went to the place of occurrence after my office was over. Meanwhile, police from Nunmati police station arrived at the place of occurrence. Police carried out investigation and questioned me. My lord, it is significant to mention here in that PW4, as doctor is also a police officer. And he has also specifically stated that by the time he reached the place of occurrence, the police has already arrived there. Now, my lord, may kindly come to PW5 at page 20. My lord, according to me, her testimony is very relevant. Though the learned trial court has not placed any reliance on this PW5. May I read, my lord? I knew Rumi Borwa of our housing colony. I do not know the accused present in the dock today. I do not remember if I have seen him before. Rumi Borwa is no more. We saw her lying in the bedroom with bleeding injuries on her belly and neck. That day was 22/12/2010. That day, Rumi Borwa had been sitting in our house till 6:30. My lord, this time is going to appear to be very significant. As per this witness, till 6:30, Rumi Borwa has to be alive because she has specifically stated that till 6:30, the deceased Rumi Borwa was with PW5, that is Meenakshi Buragohai. Thereafter, when I was going by the front of the Rumi Borwa's house, her tenant, Mrs. Soikia, called me and told me that she had heard screams of Rumi Borwa, but the door was kept shut from inside and that she did not hear her voice later. I called my neighbor, Funu Sankakoti, who resides in front of my house, and other passed by. Then I kept the dog inside the house and went to Rumi Borwa's house again. Then a lot of people gathered there. The people who had gathered there entered Rumi Burwa's house by the other side. Upon entering the house, we saw the Rumi Burwa lying dead on the floor of the bedroom, and she was bleeding. Later, police arrived there and examined us. My lord, I'm not going to cross-examination. Now, my lord, I'm coming to PW6, and PW6 appeared to be the most vital witnesses, independent witnesses of this case. And the learned trial court has relied very heavily on this particular PW. May I read, my lord?
The-
At the time of the incident, I was living as a tenant in the ground floor of the Rumi Burwa's house. I know the accused present in the dock. At the time of the incident, accused was working as a painter in the house of the Rumi Burwa. On the day of incident, accused did not work in the house of the Rumi Burwa. On that day, Rumi Burwa went to have a feast somewhere. I do not know when she returned home. Around 3:30 p.m. on that day, I was washing dishes in the kitchen. Just at that time, on hearing a sound above, I came out. When Rumi Burwa called me as Baido Baido, I went there in a run and reached her veranda. Then I banged on the door and on the window, but no one opened the door. Rumi Burwa lived alone. Then I came to the ground floor, entered my room, and waited to see as to who would come out. Thereafter, I witnessed through the window that accused Soleiman Ali came down from the upstairs and went outside the gate. After closing the gate, when he turned back, I saw his face. Then I came out and saw Meenakshi Burwa. I called her, other neighbors. Out of fear, I did not enter into the room of Rumi Burwa. After having a look on Rumi Burwa, my daughter informed me that Rumi Burwa had died. My lord, this line is very significant, that after having a look on Rumi Burwa, that means she has categorically stated that her daughter has went into the room of Rumi Burwa where she was lying dead. The last full sentence, my lord.
That can be that's neither here nor there.
No, my lord, these things
Everything is not in
appear-
secret.
sometimes appear to be very significant in a criminal case because prosecution needs to prove a case, my lord, beyond reasonable doubt. Now, my lord, I'm coming to the cross part. Rumi Burwa lived in the first floor of the house. Accused painted the ground floor where I live. When Rumi Burwa called as Baido, I was washing dishes. Immediately, I went upstairs and banged on the door and on the window of the Rumi Burwa's room. I did not get her response. At the time of the incident, Rumi Burwa's husband was on duty. At that time, no other family members of the Rumi Burwa were there in her house. If anyone came to her house, she used to inform me about the same. After receiving no response from Rumi Burwa, I left from there shouting along. I went inside my house and started to watch as to who had gone. When the accused went out by opening the gate, I saw him. I do not remember whether police recorded my statement 1 month after the incident or when. It is not a fact. I did not state in my statement before police that I was watching through the window to see as to who would go out. My lord, this is a clear contradiction. Because in her chief, she has specifically stated that I witnessed through the window that accused Soleiman Ali came down from upstairs and went outside the gate. After closing the gate, when he turned back, I saw his face. But this is the statement that has not been made before police during recording of the statement under 161 of the CRPC. It is not a fact, I'm repeating the sentence, my lord. It is not a fact that I did not state in my statement before police that I was watching through the window to see as to who would go out. Occasionally, the guest visited Rumi Burwa's house. Rumi Burwa had a house having bamboo walls in the backside of the house where we stay. A boy by a name Tutu was there as a tenant. On the day of incident, Tutu was not there. Rumi Burwa's room is not visible from the window through which I was looking. I do not know as to how Rumi Burwa died because I could not go to see her dead body. At first, I saw the accused from behind. When he turned back, I saw his face. It is not a fact that my statement and that eyewitness accused at the gate is false. Now, first thing, my lord, it is no longer a dispute that the deceased has died at 4:30 p.m. as per PW1 and PW6 as well. But PW6 categorically stated that till 6:30 p.m. the deceased was in her company. If somebody is alive till 6:30 as per PW5, then how can the accused, even if, my lord, I am assuming that he went to the house and went out by 4:30, then how could he murder? Because from the prosecution witness, it is revealed that the deceased person was alive till 6:30. And PW1 was quite specific in his statement
Is the
that
records
the
here?
murder took place at 4:30 p.m.
Yes, Lordship. Date was also wrong.
Is the,
Date was also wrong. 22, 12,
ah,
11.
date is also wrong.
This is basically the incident of 22/12/2020, and some of the witnesses stated that 22/10 instead of 12/2010.
So what is the,
Lordship, I
PW5, what does she say?
Well, my lord, I am not placing a reliance on PW7, so I am skipping it.
Age?
Page 25, my lord, this is the PW7. I'm entirely skipping it. Neither prosecution nor I am relying. My lord asked something to my,
I asked it. I wanted to know what PW5 says.
Lordship, I'm
in the evidence.
statement.
Is it in Assamese?
Yes, my lord. But,
The evidence is in
sometimes
Assamese.
it has to be in
Evidence
Assamese, my lord,
was
but I doubt.
No, evidence.
161 statement are with me or
I want
not.
to see the evidence. This is a type copy. No?
Yes. Maybe I missed.
Yes, carry on this. PW, next PW7, you're not relying. Why?
My
Let
lord,
us
I am
see
not
what
relying
does
because,
PW7 say.
my lord, PW7, my lord, I can read. That is not a problem. My lord. Let me read that. I saw the accused in the police station. I did not know him from before. The incident took place on 22nd December 2010, around 1:45 p.m. And he is giving it another time, my lord. On that day, I went to Komarkusi Prasad Bhavan and around 8 p.m. returned home. He went to Komarkusi Prasad Bhavan and around 8 p.m. he returned home. The incident took place in the colony. The place of occurrence is about 1 furlong away from my house. When I came to the colony, I saw many people there. When I asked him, people said that Rumi Borwa, a resident of the colony, had been hacked. When I went there, police was already present there. We all people there were at the gate of the Rumi Borwa's house. Rumi Borwa's house. Police did not allow us to go inside. Till then, I was not aware about Rumi Borwa's death. Around 10 p.m. on that day itself, when we requested police, they also allow us to go inside. Going inside, I saw large amount of blood spill on the floor of the Rumi Borwa's drawing room. Thereafter, when we asked Rumi Borwa's husband, he showed us the room where Rumi Borwa used to live. Going there, we saw Rumi Borwa lying injured on the floor with blood on her wearing apparel. We also saw on several fingers of Rumi Borwa lying a little away. We saw Rumi Borwa in a motionless state there then. Thereafter, in a night when we were there, police brought sniffer dog. I heard people shouting as a person is apprehended. On the following day, we all, the people of the colony, went to the police station to see apprehended person, and we all saw the accused at the police station. I came to know that the arrested person was a painter. I also came to know that the painter had killed Rumi Borwa. This is the cross part, my lord. I saw the accused at the police station on the following day of the incident. I had never seen him before. Police examined me. On that day, a lot of people gathered in front of the Rumi Borwa's house. Many people of the colony were with me. Going to the house of the Rumi Borwa, at first, we did not know as to who had killed her. I witnessed the dead body of the Rumi Borwa in her house, but I did not know as to who had killed her. Now, my lord, I'm coming to PW8. PW8 is another relevant witness to this case, may not be as relevant as PW6. And PW8 is the daughter of PW6, my lord. Because both are the tenant to the house of Roman Borwa and his wife, this is Rumi Borwa. May I read, my lord? On the day of incident, I saw a person from behind when he was going out from the house of Rumi Borwa. As such, I cannot say for sure whether that person was the accused who is present in the dock today. My lord, this is very relevant. My lord, may kindly take up the second sentence. As such, I cannot say for sure whether that person was accused who is present in the dock today, because she had not seen her face. His face. See his face. I'm sorry. We lived in a colony, in the colony of the person by the name of Roman Borwa. The name of Roman Borwa's wife is Rumi Borwa. Rumi Borwa and her family members lived in the first floor, and we lived in the ground floor of the same house. The incident took place on 22nd 12, 2020. At the time of the incident that day, I was sleeping in my house after returning from college. Just at that time, my mother heard sound of stomping and falling of articles on the first floor. Then my mother asked me to get up, saying some untoward incident might have taken place on the first floor. Then I made a call to Rumi Borwa. I found the call disconnected. Thereafter, I again made a call, but found her phone number not reachable. Then I came outside the house and looked towards the upper floor, but saw nothing. After that, we again entered inside our house. After that, on hearing the sound of the opening the gate, I looked through the window and came outside. And then I saw a person going out of the house. The person was clad either in orange or in a brown color shirt. Thereafter, my mother and I again went to the first floor and banged on the door of the Rumi Borwa's house, but nobody answered. And the door was locked from inside. Then we tried to open the door, but could not succeed. Then we informed Meenakshi Borman, who lives near our house, about the sound which we had heard on the first floor. She then called other neighbors by raising an alarm. It was around 4 p.m. Then, when the neighbors arrived there, we again went to the first floor and knocked at the door of the Rumi Borwa's house. But when no one came out, the neighbors went to the second floor through the staircase and started to scream. At that time, the door of the second floor was open. Then all the people started screaming Marile Marile and started crying. Around 6 o'clock following morning, I came to know the police has arrested a person by name of Suleiman Ali. I have never seen the accused before. I heard that he was a painter. Now I am coming to Prosper. On that day, I did not enter. My lord, this is very significant. The first sentence of the cross part. On that day, I did not enter inside the house of the Rumi Borwa. On that day, my mother, Omio Soikia, did not enter inside the house of Rumi Borwa. I heard that police had arrested the accused in his hometown. I do not know who first entered inside the room on that day. My mother and I met Meenakshi Borwa at the gate of our house on that day. So, my lord, if we compare the testimony of PW6 and PW8, then there is a glaring inconsistency.
What is
between
the, what is
testimony.
the glaring inconsistency?
Now, first of all, the PW6 has stated that it is not her, but her daughter. That means PW8 has entered into the house. Of the
Where does he say that she entered into the house?
My lord, I'm coming. My lord, may kindly again come to page 23.
Yeah.
Page 23. I'm reading the last 5 sentences
Yeah.
of the first paragraph.
Yeah.
Then I came out and saw Meenakshi Purva. I called her and other neighbors. Out
Yeah.
of fear, my lord, may kindly note this
Yeah.
sentence. Out of fear, I did not enter into the room of Rumi Purva. After having a look on Rumi Purva, my daughter informed me that Rumi Purva had died.
Having a look could be from the window also. Doesn't mean that, where
No.
does it say that she entered the room?
No, because, but
If they can see
PW8,
from the
no, but
window.
my lord, PW8 not only denied
You
that she
see,
has
you see,
entered.
out here, you see,
Ah.
page 23, the witness says,
Hmm.
PW6 says, I witnessed through the window.
No, my lord, I'm
That
not,
is Suleiman,
I'm not about whether the accused has entered or not, whether the accused has, whether she has not entered.
Ah.
But as per
Neither
her
has the daughter
statement,
entered.
she has stated that out of fear, she did not get into the house of Rumi Purva,
Correct.
but her daughter had entered and she,
Where does he say that the daughter entered?
yes, out of fear, I did not enter into the room of Rumi Purva. My lord, may kindly come
Yeah.
to the last 4 sentences of
Yeah.
the first paragraph.
Yeah.
Out of fear, I did not enter into the room of Rumi Purva.
Correct.
After having a look on Rumi Purva, my daughter informed me
Yeah.
that Rumi Purva had died.
So could it be from the
My lord,
window?
How can somebody say that somebody has died without looking? But PW8 in her statement has categorically denied that either she had seen.
It could be a guess, it could be, but
No,
then
my
it
lord.
doesn't, you see, it doesn't mean that it doesn't mean that the daughter had gone inside the room. Can't it be seen from the outside through a
No.
window?
She did not even state that, my lord. that
No,
she
but
had
then
seen
she
the
has
dead
not
body.
stated that she went inside also.
No, my lord.
Why are you putting words into her mouth which is not there?
No, my lord. There are certain things to be inferred, my lord. Everything may not necessarily is to be written, but she has denied that I did not enter inside the house of Rumi Purva. On that day, my mother, Umyo Soikia, did not enter the house of the Rumi Purva. I heard that police had arrested the accused in his hometown. I do not know who first entered inside the room on that day. My mother and I met Meenakshi at the gate. My lord, she has also not stated that she has seen the dead body of Rumi Purva. No. I'm assuming that my lordship is right. It is not necessary to go inside the house. Somebody can look from the outside through the window. Maybe. But at least this particular fact needs to be stated in the testimony of a witness, my lord. When it is not being stated, it may not be fair in a criminal case to assume something on our own. That is my humble submission before this honorable bench, my lord.
Okay, then.
And just for my satisfaction, my lord may kindly now turn to just a moment, my lord. Let me give him a minute.
33.
No, my lord, not 33. So far as the PW6 is concerned, my lord, her 164 statement has also been recorded. And she is even inconsistent with her own statement that she has made under section 164. My lord, may kindly come to page 123.
No, let us finish the witnesses first.
No, but my lord, why am I referring to
123.
page 123? This is the statement made by the PW6 itself, because her statement is recorded under 164 before the magistrate as well. Page 123. May I read, my lord?
Yeah.
At about 3:30 p.m., my lord, time is very relevant. At about 3:30 p.m. on 22/10/2011, which is not correct, 2010, I was washing dishes at home. I stayed in the ground floor flat and Rumi Purva stayed in the first floor flat. When I was watching the dishes. I heard sound akin to someone weeping upstairs. When I reached the middle room from the kitchen, I heard the sound from the upper floor flat, which was akin to the sound produced when chairs fall to the ground. After that, when I came to the front veranda, I heard Rumi Burwa shouting, Baido, Baido, Baido. Then I went upstairs at a run to see what had happened. Then I rang the doorbell, banged on the door, and called Borwani Borwani. Since I did not get any response, I got scared and came down. Coming downstairs, I woke up my sleeping daughter. Regarding this, my lord, she has not stated anything in her testimony, that she has woke up the daughter. I woke up my sleeping daughter. When I told her about the matter, she made a call to Rumi Borwa. Then, hearing a sound in the hall, I came to the veranda. From the veranda, I saw a young youth going out of the hall, and then thinking as to who might be, I came near the hall. When I reached near the hall, the youth turned to look at me, and then I could recognize him. Earlier, that youth painted Rumi Borwa's flat and the veranda and the door of the flat. I looked at the surrounding to see if I could find some other person. Then I saw Guhai Baidu. She came to walk her two dogs. She called some other people. Other people went upstairs. My daughter also went upstairs. She returned in tears and said to me, someone killed Anne. Out of fear, I did not go upstairs. After that, Rumi Burwa's husband arrived. The police came. While watching television, when I saw the youth who had gone out, I became sure that it was he. He is about 20 to 25 years old, my lord. The first inconsistency is that, my lord, in her testimony, she has stated that she had peeped through the window to see the face of the accused person, where in her 164 statement, she has stated that she has seen from the veranda. And my lord, she again stated that at around 3:30 p.m. So murder might have taken place around 3:30. But as per the PW5, she was still alive and in the company of PW5 till 6:30.
We'll come back after 1 minute.
on PW6 is that PW6 is a very vital witness for the prosecution. Whenever a particular witness becomes vital for prosecution, that also becomes very material for the accused as well. So I would like to put at this point of time, my lord, how far it is safe to rely entirely on PW6 to convict the accused person and put him into jail for his life. Because,
What about the other witnesses? Have you finished?
no, my lord, I have
Then they
not.
finish first, huh?
Then, my lord, let me read first, then
Huh?
I will- let me complete with the evidence.
Yes,
And
yes, that's
thereafter I
what.
will make my submission. But there are some witnesses. My lord, let us come to PW9 then. Though I'm not very much-
PW9, nothing to say.
nothing to say.
There PW10, PW10
PW10
also.
is Minoti Dekar.
There's
There's
nothing
nothing
much.
much to say, my lord.
And then
Let me check once, my lord. My lord, may I kindly come to page 36.
yeah,
My lord, PW11 is the painter who worked with the accused Solomon Ali. That is why his testimony is material. I know accused Solomon Ali. I work as a painter. The incident took place in 2010. Some 3-4 days prior to Rumi Burwa's death, I painted the latter's house. Some 10-12 days ago, Solomon Ali worked along with me in Rumi Burwa's house. We worked there on daily wage basis. We received our wages on time. In the evening, on the day of occurrence, I learned from people residing at the colony that Rumi Burwa had been murdered. On receipt of the information, I went to her house. Many people had already gathered there. Rumi Burwa stayed in the flat on the first floor of the house. There are 2 staircases that one can use to reach the first floor. One can go upstairs either by using the staircase by the side of the veranda or by the stair along the garage, alongside the garage. I learned from people that Solomon Ali had killed Rumi Burwa. Police questioned me. Cross part, my lord. Solomon Ali worked with me as a painter for some 15 days, some 4 or 5 days prior to Rumi Burwa's death. We finished the work of the painting of the house. I did not go to Rumi Burwa's house after completion of the work. Earlier, Solomon Ali never worked with me. Rumi Burwa handed me the money that was due to me for painting the house. I gave money to Solomon. We had some 3-4 painters. I did not see the dead body. I did not enter her room that day. I learned from Rumi Burwa had killed the first floor, had been killed in the first floor. I never went to the second floor flat of her house. It is not a fact that my statement that I later learned Rumi Burwa had been killed by Solomon Ali is false. Now, my lord, PW12 is the DFSL. Because certain articles were being seized and those articles has been sent to DFSL for verification and examination, medical examination. Now, my lord, in this case, my lord, may kindly come to page 41. I'm not reading entire testimony of PW, but there are some material things, my lord, I would like to point out from page 21. The first sentence, Exhibit 21, serial number, that means serial number 2741/B, 2741/C, 2741/D, and 2741/E. These are the articles, my lord, that those have been seized from the accused person. And these articles were being my lord, now may kindly come to page 39. These are the article number 3, 4, and 5. 3 is the Samsung mobile phone. 4 is one girl mobile phone with 2 number of extra mobile battery with bloodstained cloth, and exhibit 3 contain Nokia mobile phone with the stain of suspected blood. I have numbered the exhibit as 2741E. Now, my lord, the opinion of the doctor regarding this article is that gave positive test for blood only, but its origin could not be determined due to insufficient test material. So, my lord, if medically it is only been proved that this certain blood has been plotted over this material, but how does they prove that these are the blood of the accused person? Because, my lord, may kindly come to page 39 at the bottom part. What is the opinion of the doctor, my lord? These are the article that has been seized from the house of the victim. Gave positive test for human blood of the accused.
Where is the question of blood of the accused person coming into the picture?
No, that is, my lord, it is coming to the picture because at least to the extent it has to be proved, the blood contained in those articles
There was
belongs
no
to the human blood.
huh?
The blood contained in the material, which has
Ah.
been seized from the accused
Yes.
person, belongs to human blood. Even
Ah.
that has not been proved that it is a human blood.
How does it matter whether it's human blood or not?
Blood sample, 24. Two numbers of blood samples said to be accused person in editor file. In editor file, 24. Page number 40.
Okay, accused, 24, page 40. Come to page 40, Mr. Counsel,
Yes, my lord.
serial number 24.
Serial number 24. Two manner of blood samples to be of accused person in EDA vital. I have examined because my lord, a blood sample has been collected from the accused person. The moment he has been made appear before the magistrate, a prayer has been made by the IO to take his blood sample. My lord. This is relating to that only. Serial number 24.
What is this EDTA?
DNA testing.
EDTA.
But my lord, it is nowhere been proved that the blood sample has been matched with the blood sample from the seized article. Now, my lord, let us come to the PW 30.
Just a minute, let us see this. Is this exhibit? Exhibit 5.
It is certain kind of, my lord, chemical based test done in DSFL. The pronunciation is quite critical, my lord.
Ethylene, EDTA is ethylenediamine tetraacetic acid. It's a
Tetraacetic
polyprotic acid containing 4 carboxylic acid groups and 2 amine groups with lone pair electrons. I think chemicals used for determining.
My lord, if the samples of the blood has been, if the sample of the blood has been extracted from the body of the accused, that has to be matched with those articles that has been seized. Whereas prosecution has alleged that these are the articles contained with blood clot in those articles. But that has not been established by the DSFL report. This is the only point I want to make, my lord. Now, my lord, at page 42, this is the testimony of the wife of the accused, my lord. She has said nothing about the occurrence. So we can skip.
What is your blood group?
My blood group, my lord.
No, FLS blood group.
My lord, that is not in my knowledge. My lord. Because that has not been annexed, but from the report that has been submitted
Exhibit so and so.
by the concerned officer of DFSL,
Positive test for human blood.
he stated nowhere that sample of the blood sample of the accused has been matched with the blood that has been plotted in any of the articles that has been seized by the prosecutor or by the investigating officer. That is for certain. And that particular order is there, by which order the court allowed to take the blood samples from the accused person. Now, my lord, PW 14 is the witness who has done post-mortem examination on the dead body of the victim. Now, my lord, from this particular report also, I find the report and the opinion arrived by this particular witness is also very vague. Now, there is a query that has been made. I am referring to page 45, last part, to quote. This is the question put by the court. Page 45, my lord.
Just a minute.
Yes.
Who is this PW 14?
PW 14,
Doctor, my
post-mortem report. my lord.
Doctor who examined the deceased.
Yeah, exactly.
Doctor, my name is R. Chaliha. Chaliha.
Achha liha, my lord.
Doctor,
Yes.
Yes, my lord. But in his cross, he has stated that he has not done the post-mortem on his own. It might have done by somebody else, but these are the official documents, my lord. So I'm not questioning. My lord, first, I would like to take this honorable bench to page 45, the last part of the page 45,
Yeah.
to quote. The court has put some query to this witness answered. The above injuries as referred are sufficient to cause death of a person in normal course of nature. Now, my lord, may kindly come to page 44. I'm particularly pointing out the first three injuries, how these injuries can cause death of the accused person, my lord. The chop wound of right hand involve ring, middle finger, and index finger. Right ring, index finger are separated from the rest of the body. Incised wound of size 4 into 1.5 cm X bone deep in presence over the nose.
where are you
Perpendicularly,
reading? Where are you reading?
my lord, at page 44. I'm referring to first three injuries that has been caused. The chop wound of the right hand involve ring, middle, and index finger. Right ring and the index finger are separated from the rest of the body at the level of proximal phalanx. Right middle finger is attached with hand by a skin flap. Incised wound of size 4 into 1.5 cm into bones deep is present over nose, perpendicularly placed 0.5 cm away from the middle extending to glabella. Incised wound of size 3 into 1 cm into X muscle deep present over the right side of the chin 1 centimeter away from the middle line and 3 centimeter below the lower limb. Well, these injuries cannot cause death to an ordinary, under normal circumstances. But to the query made by the court, this particular witness stated that the above injuries as referred are sufficient to cause death of the normal death of a person in normal course of nature without discriminating.
According to you, these injuries are not sufficient to cause death.
These three injuries normally
These three
cannot cause
Yes,
death
so
to
the- but what
death-
about the
death
rest?
to a person.
What about the rest?
There are some other injuries which might cause.
Then,
But it appears, my lord, this particular witness is not serious about the report that has been brought by him to the court. Otherwise, this particular witness would not have made this kind of statement. My lord.
what?
That all injuries are sufficient to cause death without any discrimination, my lord. Looking into the nature of the injuries that they exhibited in the report, my lord, appeared in the report.
Why not?
Then, my
have
lord,
you heard of people
yes, my lord.
trying to kill themselves by slashing their wrists? Now, why, according to you, slashing of wrist might be might not look very serious. But you see, what is the seriousness is that the blood flows out.
Yes,
Then they die because of that.
otherwise, this is a very vital
That's-
space in a
that-
human body where several nerves are going through. But my lord, cheek, nose, because 2 and 3 refer to cheek and nose, my lord. The injuries may be very deep and inside, but that does not mean
You,
that somebody
you
might
cannot
get
be a
killed
super
by such
specialist.
injuries.
So you're a super specialist.
No, I am not. a
You
super
said that you
specialist.
are an
But, my
expert.
lord, I'm questioning the veracity.
You have to
of his
question it.
understanding.
You question it.
Yes, my lord.
You question it with medical evidence, not with what you believe is correct.
Yes, my lord.
See, a doctor is an expert in his own field.
No, doctors.
If you say that you are better than him, I don't believe in him, then God can help us. Next time, we'll come to you for treatment. We won't go to this kind of department.
I'm just putting my view.
No, your view is okay, but then you're supposed to be also practical.
Yes, madam.
When the doctor has said something, can we go against the opinion given by a doctor with regard to a medical injury, with regard to an injury? Than to a lawyer. Otherwise, next time we'll go to some lawyer saying this is the case. What to do?
Yes, madam.
What you're going to give me Picosul or you're going to give me some cough syrup or what? We have got to be also
That I totally
practical
understand.
in our way of looking at
And
things.
I'm also accepting the views that has been brought forward by my lords.
It's not that. The Supreme Court has held so many cases.
Yes, madam. Of course.
Education expert. Medical expert.
The point I want to make is that from the report and the testimony, it should appear to us reasonable. That is my only point. But I have also considered the views that has been offered by my learned lordship. Now, my lord, I am coming to page 46. He is a seizure witness man. Because, in my opinion, the prosecution has miserably failed to prove seizure from the accused person. So this witness become very vital. My lord, may I read PW 15? His name is Samsul Hussain. Accused Suleiman Ali is known to me being the son-in-law of Ahmed Ali of my village. On 23/12/2010, police went to my house and requested me to show the residence of Ahmed Ali of our village, and accordingly took me to the house of Ahmed Ali. And upon arrival on that house, police inquired about the presence of his son-in-law Suleiman Ali, to which he replied in positive. Police, by entering into the house of Ahmed Ali and brought accused Suleiman Ali from inside. I was standing outside when police searched the house of Ahmed Ali. Police took my signature in one paper, height Exhibit 4. Exhibit 4 is my signature. Now, my lord, I'm coming to cross. Cross is very vital. In my presence, police did not seize any article. My lord. So, as per this witness, the seizure has not been proved. As alleged by the prosecution, the certain article has been seized from the accused person, has not been proved.
So where is the Caesar list?
My lord, may kindly come to.
Is 125 on.
My lord, there are 4 Caesar witnesses altogether, but I'm referring to Caesar list, the article that has been seized from the accused, that your lordship will find at page 131. Page 131, my lord. This article has been seized by one SI Didas, and description of the seized article, one Samsung handset bearing number so and so, SIM card containing so and so, one mobile handset along with 2 SIM, Aircel, Airtel Aircel, I think, one Nokia handset with SIM card number so and so, 2 extra battery, cash 5200.05 containing blood stain, one Zine pen, blue color containing blood stain, key color shirt containing blood stain. And now, my lord, may kindly come to page 132. There your lordship will find there are 3 witnesses to this seizure list. I have already read the first witness, that is Samsul Hussain. He did not support the seizure. And my lord, there is another witness, Hatim Ali. He has been declared hostile by the prosecutor. So question of supporting the seizure list by this witness does not arise. And there is also a third witness, my lord. I'm referring to page 132. Ramzan Ali has not been examined by the prosecutor. So these are the only 3 witnesses to this seizure list.
Hatim Ali is PW number?
PW, he must be 18, my lord. Let me check, my lord.
PW 17.
PW 17. PW 17.
Then
Then my lord may kindly come to PW 16. For me, and for my defense, my lord, this witness seems to be very important. Let me read, because he is the witness who has examined accused after he being arrested. He was brought before the MMC and he is a doctor who has examined the accused person. May I read, my lord? On 23/12/2010, I was on emergency duty in MMC hospital and was working as an emergency doctor in the state hospital at that time. On that day, at about 5:30 a.m., my lord, this time is very significant. Third sentence, on that day, at about 5:30 a.m., one Muhammad Suleiman Ali, aged about 23 years old, male, was brought to the hospital by Para 14 of Assam Police in connection with Nunmati PS case so-and-so under section so-and-so IPC for medical examination. The said Suleiman Ali was identified by Para 14 staffs accordingly. I had conducted medical examination of Muhammad Suleiman Ali and found the following: two numbers of incised wound on left palm of the hand near the root of the middle finger and index finger, 1 inch into skip deep, fresh. One lacerated wound at the terminal phalanx of right middle finger, size 1/4 inch, 1/4 inch into skin deep, fresh. Tenderness over both popliteal fossa. It is a back space of the knee, my lord. For the third injuries, I referred Muhammad Suleiman Ali for surgical OPD. The opinion of surgical OPD was awaited. Ill wrote my opinion, my lord. I gave my opinion with reference to injury number 1 and 2 only, and could not give for third as the report of the surgical OPD was yet awaited. Injury number 1 was a simple injury caused by a sharp object. Injury number 2 was a simple injury caused by a blunt object. Injuries were still bleeding and fresh, my lord. This is very relevant. Injuries were still bleeding and fresh. Accordingly, I gave my opinion by Exhibit 7, whereon Exhibit 7.1 is my signature due to lapse of time and also come across so many people every day. I shall not be able to identify the person whom I examined that day, even if I see him. Now, my lord, the cross sentence. My lord, there is only one sentence for the cross. My lord, the injury being fresh, we mean that its age is within 6 hours. Now, my lord, he was brought to the doctor at around 5:30 p.m. And he was ascertained with some fresh injuries. And the age of the injuries, doctor has ascertained to be 6 hours. Now, if we reverse in time from 5:30 a.m. for 6 hours, my lord, it could happen around 11:30 to 12, not prior to that. So there cannot be any question, my lord, as per this medical opinion of this doctor, as my lord has rightly stated, that this injury could have occurred due to scuffle between the victim and this accused person. This injuries has nothing to do with that, as per this medical report. Because he was produced before the doctor at 5:30 a.m. and doctor is ascertained.
and post-mortem examination is at what time?
Post-mortem examination is, time has not been described, my lord. Let me
Same
see.
day.
Better question, yeah?
Arrival of dead body, examination 11:40 AM, 23/12.
Hmm?
23/12/2010, 11:40 AM. Time of
PME.
examination.
Which, by the page,
Page 137.
137. But somewhere I have read the expert who has conducted the post-mortem upon the dead body, he has opined that the death cause between 12 to 24 hours from examination of the dead body.
Yes, page 142. Time since date.
Page 142. Yes, my lord. It is reflected in the page 142 that time since death 12 to 24 hours. The gap is relatively large, my lord. It's very difficult to ascertain. My lord, can I proceed further? Now, my lord, I'm coming to PW 17. He is another seizure witness. His name is Hatim Ali, and he has been declared hostile by the prosecution. Could I read, my lord? Page 50.
Yes.
I do not know. I do not know the informant Roman Borwa. I know the accused Soleiman Ali, whose in-laws' house is in my neighborhood. I know the Samsul Hussain, who is our village headman. I also know Ahmed Ali, who is the father-in-law of the accused Soleiman Ali. I do not remember the date, month, year of the incident, though the incident has taken place almost 4 or 5 years back. It was around 1 to 1:30 a.m. when I was sleeping in my residence. I heard that village headman was calling me from my courtyard. When I came out in the courtyard, I saw that along with the village headman, police was also there. Thereafter, the police headman asked me to accompany him to the house of Ahmed Ali, stating that police had come to his residence. Accordingly, I went to the house of Ahmed Ali and saw that the hand of the accused Suleiman Ali were tied and the OC of the police station was writing something in sitting position. Then the village headman introduced me to the OC and told that I was a resident of the neighborhood. Police asked my name, father's name, and told me that he had gone from Guwahati to apprehend and want me to be a witness to arrest of the accused Soleiman Ali. And accordingly, on my agreeing to be a witness, therefore, my signature were taken on a paper. My lord, according to him, he has only testified to the extent that the accused person has been arrested, not in reference to the article that has been seized from the accused person. Now, my lord, I'm reading further. As these witnesses substantially resile from the statement allegedly made before police under 161 of the Criminal Procedure Code and has not supported the prosecution case on the prayer made by the learned additional public prosecutor, the prosecution is allowed to put questions to him which can be put during cross-examination. Now, as per the cross-examination by the prosecution, it is not a fact that I had stated before police that Soleiman Ali had confessed before me that he has killed a lady in Nunmati. It is not a fact that I had stated before police that material referred to in Exhibit 4 were shown to me and that said article were seized in my presence from the accused. It is not a fact that the Soleiman Ali is my co-villager. I have deposed falsely today. It is not a fact that Exhibit 7 is the statement recorded by police under 161 of the Code of Police Station. Now, there is only one sentence cross that has been made on behalf of the accused. I have not seen anything be seized from the accused person. But overall, the seizure from the accused person has not been proved anywhere in this case. And PW 18 is a police officer from Nunmati police station, my lord. My lord, date is quite different. Every police officer giving a different date, my lord. On 22/10/2010. On 22/12/2010 at 8:30 a.m. It should be PM, my lord. It cannot be 8 a.m. On 22/12/2010, 8:20 p.m. A resident of Narengi House Colony, Sri Muntu Deka, had informed the inspector S. Dotto over phone that some unknown miscreant had killed a resident of the said housing colony, Srimati Rumi Borba, and has escaped. As soon as the information was received, a ZD diary entry number 949 dated 22/12/2010 was made by Sri K. Guhai, Inspector and OC of the Nunmati PS. Thereafter, along with the Deputy SP, Sanmari Police Station, ASI Akbar Ali, ASI AJ Borguhai, SI Sri Soikia, and other police staff went to the said housing colony for investigation. These are the my lord ZD entry. Now I am coming to the cross part. On 24/2015, the officer in charge of the Nunmati Police PS was Sri B.D. Sharma. General diaries entries are generally scribed constable on instruction from the OC, and then OC put his signature thereon. I cannot say who was the Sirastadar at the Nunmati police station at the relevant during the period of Exhibit 8. Pages in Exhibit 8 starts from serial number 6. In Exhibit 8, some pages are seen missing from it. Even the GD entry that has been produced before the court, there are certain GD entry which are being missing. Why does so happen, my lord, in this case? Otherwise, this is a very relevant piece of evidence, my lord, because at what particular times police officers is performing what kind of duty, it can only be ascertained from the GD entry. The moment GD entries are missing, my lord, we cannot ascertain who is the police officer doing what kind of duty. Now, my lord, PW 19 is the executive magistrate who has conducted the inquest report. My lord, only one thing I would like to point out, my lord. I'm not reading these particular witnesses, but my lord may kindly come to page 34, page 54, page 54. I'm reading the second sentence from that thought. The right leg was found normal.
Who is this PW 18?
My lord,
Is the IO.
PW 20 is the IO, my lord.
PW 20 is the IO.
IO. My lord, from page 54, I would like to point out just one fact. This executive magistrate who has conducted the inquest examination on the dead body, she has categorically stated, my lord, the private parts were found normal. So the private parts were also found normal. The bag was also found normal. That means, my lord, there may not be any sexual assault on this particular lady.
So that is not an issue here.
That is not an issue. That is, of course, not an issue. My lord, PW 20
Yes.
is another vital witness where prosecution has miserably failed to establish certain facts, and those facts has been tried to be covered up by the PW 20. So, I may be allowed to read. My lord, this PW 20 begins from on 22/10/2010. It is not a case of 22/10/2010. It is a case of 22/12/2010. As per the FIR. My lord, why it should not be taken? Yes, yes, my lord. This I should not be hyper technical, but when this kind of mistakes has been made throughout the testimony, then a doubt arises. Throughout the testimony, the same mistake cannot be repeated again and again throughout the testimony of the IO. This is the fact I would like to point out. Yes, my lord, in some places there may be a typographical error or every human being is a part and parcel of some error.
FI is of 20 to 12, my God. It was 12, no? 20 to 12, FI.
Translated transaction payment.
But this is the original. This is the original. PW 20 evidence is original. This is the original.
Yes.
correct?
Yes, my lord, it is in original.
Signature is.
But there are certain pages which are not in original. Let's say for page number
Xerox.
62, that is not original. It has been typed.
Xerox, no? Photocopy.
Who is this magistrate? Let me see.
It's on additional session, this number.
79. everything. Naimuddin Ahmed.
No,
Akbar Ali.
it's on
Akbar Ali.
additional session, this number. Amru. Was
His-
recorded.
his name is Naimuddin Ahmed.
He wrote the session. But recorded by someone, some other.
Okay.
Utpal Prasad, additional signature.
But then he also should have seen, no? Yes, carry on.
Should I begin?
Yes.
But ma'am is trying to verify something from the record.
Carry on.
Ma'am, should I proceed with the testimony of PW 20?
Yes.
Yes, my lord. On 22/10/2010, I was working as an attached officer at the Nunmati police station in Guwahati. On that day, at 4:20 p.m., my lord, time is very relevant, the resident of Narengi Housing Colony, Inspector Someshwar Datta, he is happened to be the PW4, my lord, had informed me at the police station over phone that a resident of that housing colony, namely one Montu Deka, one of the said housing colony, had informed him that some miscreant had killed another resident of the said housing colony, namely Rumi Borwa, and has escaped. After receiving the information, the officer in charge of the Nunmati police station made a general diary entry number 949 dated 22/10/2010. Again, 22/10, not 12/2010, and informed the Deputy Superintendent of Police, Sanmari Division, who was present at the police station itself. And thereafter, the officer in charge of Nunmati police station instructed me to proceed to the place of occurrence. And accordingly, I, along with the Deputy Superintendent of Police, Sub-Inspector of Police, M. Soikia, along with other police staff, proceeded towards the place of the occurrence at this, the Narengi and the housing colony. We arrived at the place of occurrence at 4:30 p.m. and visited the place of occurrence, which was the residence of the deceased Rumi Borwa. That is the house number 1 of the said colony, which was on the first floor of the two-story building. The entrance door was shut but not locked, and the hook of the door was bloodstained. Thereafter, we condoned the place of occurrence and did not allow anyone to enter. But a ribbon has been put. Called the forensic expert team and a dog squad team to the place of occurrence, as well as the executive magistrate. Thereafter, the executive magistrate team of forensic expert and the dog squad team arrived at the place of occurrence. Thereafter, the photographs of the forensic team took photographs of the place of the occurrence from the outside and of the inside. And thereafter, the team, along with the executive magistrate, entered into the room and found the dead body of the deceased, Srimati Rumi Borwa, lying on the floor of the room in supine position with blood spilling over, and also saw a white towel gamusa around her neck. From the drawing room of the house, mark of blood on the floor leading to the bedroom, as if the dead body had been dragged from the drawing room to the bedroom, was seen. In the bedroom and the drawing room, blood-sustained footprints were also seen. Blood was also seen on the bedsheet of the bed adjacent to the dead body. Blood marks were also seen on the tablecloth of the tablecloth of the table nearby the dead body. On the wooden chair kept near the said table, a blood-stained dagger and a scissor were also seen on the chair. The door of the steel almirah near the dead body were also seen half open, and a purse and the two blood-stained handkerchief were also seen near the steel armida. The blood was also seen on a CD kept on the TV table near the steel armida. In the door hook of the attached bathroom and on the washing machine of the bathroom, blood stains were seen. The entire crime scene was video recorded and blood-stained footprints were measured and their photographs were taken. The dead body was lying in the north-south direction with the head towards the index and the middle fingers of the right hand of the deceased were cut from their roots and were lying beside the dead body with a gold ring absent from the said two fingers, as the husband of the deceased has identified and stated that she was wearing two gold rings in those fingers. The gold chain of the victim was also missing from her neck. My lord, here I would like to point out, PW1 did not state that there are two rings and she was wearing a gold chain. PW1 specifically stated in his testimony that it was only one ring that has been stolen. I'm proceeding forward, my lord. The members of the forensic team collected the samples of different bloodstain found at the different spot as the stated above, and also took blood samples from the dead body and the garments on the dead body. Towel, dagger, scissor, bed sheet, tablecloth, etc. were seized by me from the place of occurrence. As per the seizure list exhibit 8, in presence of the independent witness, the members of the forensic team had also collected fingerprints found at the place of occurrence. Executive magistrate conducted the inquest over the said dead body in the presence of independent witness and prepared the inquest report at the place of occurrence itself. Thereafter, the statement of the witnesses were recorded at the place of occurrence. After getting leads from the sniffer dog, several persons were detained as suspects, and on the basis of their statement and on the basis of the statement of the eyewitnesses stating to have been the accused going out from the place of occurrence, accused Soleiman was identified as another suspect. The husband of the deceased, Roman Borwa, was at the place of occurrence, and from his statement, the mobile number of the victim could be mobile number of the victim could be known. The victim had a mobile handset and had also stated that the mobile handset cash amount from the steel armida and ornament owned by the victim were taken away by the miscreant. I collected the mobile number of the victim, and on the basis of the statement of her husband, the additional superintendent of police, City Sri L. Terang, who is also the nodal officer for the CDR, call detail record, immediately rang up the mobile number of the victim and could ascertain the location of the mobile phone to be at Nalbari district. In the meantime, the husband of the victim, Sri Roman Borwa, submitted a formal and a written information with regard to the incident, which was received by then OC Nunmati PS, who was present at the place of occurrence. Accordingly, Nunmati Police Station case number 487/2010 under section 448(302) of the IPC was registered and was endorsed to me for investigation. At the same time, the aforesaid additional SP had sent the requisition for CDR of the mobile number of the victim through email and has received the soft copy of the same through email. My lord, this part appears to be very significant because at the same time, I'm reading the last paragraph of page 57. Last paragraph of page 67, my lord. 57, sorry. At the same time, the aforesaid additional SP had sent the requisition for CDR of the mobile number of the victim and through email had received the soft copy of the same through email. It is the soft copy of the CDR that has been sent through email that has been produced by the IO before the court. So my humble submission in regard to the CDR, it is not even admissible, my lord, in terms of the 65B4, because there has to be a certificate, yes, issued by a responsible officer certifying the identity of that particular machine where the information has been stored.
Of what? This is with regard to messages.
No, this is not regard to
With
messages.
regard
This is
to
this regard to the messages, also regarding the call details. in relating to the phone number that has been used by the victim.
No, but then that is not the issue here. The issue
this
is
is
with
the issue, my
the
lord.
phone
This is-
being found in your custody.
No, phone has not been, because I have already pointed out by the seizure witnesses that it has nowhere been proved that this article has been seized from my possession. The point number one. And CDR has to be admissible. There has
What
to be-
is CDR?
My lord,
All details.
All detailed report.
all detailed report, my lord. And these are the considered
But
to be
what was that supposed to prove anyway?
now, that's supposed to prove, the prosecution tries to establish that the police who are at the helm of the investigation, they made a call to the phone number of the victim, and it was traced to be found in Nalbari. Now I am coming to page 58, my lord. After reaching the place of occurrence, I had also prepared a sketch map of the place of occurrence. After receipt of the first information, the dead body of the victim was sent to the Guwahati Medical College for post-mortem examination, and later, from the call detail records, the location of the said mobile and the accused was ascertained to be at Narengi at 1:04:07 p.m. Now, my lord, it is nowhere been stated that all records of the deceased accused person has been seized. And your lordship may consider, and all the seizure lists, it is, and all the seizure lists were entirely silenced regarding to what is the SIM number that is being used by the accused person. So how can police claim that the call, as per the call detail, the accused person asserted to be at Narengi at 4:01+4 my lord? The call details regarding the accused person has not been obtained from the appropriate authority. That apart, my lord, it has to be established by the prosecution that I am using so and so mobile number, and this mobile number had been traced to be somewhere in the Narengi. Unless my
You
mobile,
don't have to call to trace it. It does,
my
you
lord,
don't
it
need a
has to
call.
be, because, my lord, whenever we are using a SIM number, my
No,
SIM
you
number
see
has been
the,
connected to a particular
the
tower.
mobile itself gives out a signal.
Yes, my lord.
The mobile itself gives out a signal as to where the location of the mobile is. It does it require that it has to be used?
Yes, my lord, it has to be used, because unless it is off, my lord, it cannot be traced. It has to be in use, my lord. Because, my lord, whenever I am using my mobile, and my mobile SIM has been connected to a particular tower, and police can look at that particular tower from
See,
that
there
tower.
have been studies done where SIM has been taken out, but the location of the mobile is still traceable.
My lord, if that is being so, then somebody has to ascertain the fact that how my mobile is being traced in Narengi at 1+4 minutes. We cannot assume these things, my lord. This is a criminal case. my lord.
That's what I read somewhere. I'm not very sure
No,
about.
that might be the case, my
So,
lord. Your
I'm-
lordship might be absolutely right, but it has to be established in a case, my lord. In a case where we are going to putting somebody into the jail for his whole life. On mere assumption, my lord, we cannot make out certain our own opinion and base conviction of the accused person. That is my humble submission before my lord.
Anything else?
My lord, I am proceeding further. After sending the dead body for the post-mortem, we left PO after sealing the safe. As the location of the mobile phone of the victim was ascertained to be at Nalbari. At that time, additional SP City constituted team of officers comprising SI Mrigan Soikia, SI Dhareshwar Das dispatched the same to the Nalbari along with one witness, Chad Ali, who had stated he would be able to identify the accused Suleiman Ali and his residence. On the same night, the said team arrived at Nalbari 1:45 a.m. on 23/10/2010, and found the accused Suleiman Ali in his in-laws' house at village Garbitar, Hamadhara, under Khograpar PS, district Nalbari, as shown by the witnesses, Chandan. The village headman of the said village was taken by the police team to the house of the in-laws of the accused, and in presence of the witnesses Sadali, the father-in-law of the accused Ahmed Ali and his son Ramzan Ali, the mobile handset of the victim of the Samsung ZT so and so number so and so, SIM number so and so, having blood stain, another mobile handset with two SIM cards, one of the Airtel and other of the Aircel, another Nokia mobile handset along with the SIM card number C so and so, two extract mobile batteries of and cash of rupees 5,000 so and so, having blood stain, one jeans pant of blue color with blood stain, one yellow color full sleeve shirt having blood stain, two numbers of handkerchiefs, one gray in color with blood stain, and other towel of three colors having blood stain were seized from the accused, and as seizure list prepared at the spot and the signature of the witnesses were taken on it. The materials were seized from the accused by Exhibit 4, which I have already pointed out. Then, my lord, I'm skipping the first portion of the statement at page 59. I'm coming to Exhibit 13 and Exhibit 14. My lord, it should be at para 4. Have your lordship found in page 59? Exhibit 13 and Exhibit 14 are two photographs of the hands of the accused and of the accused respectively. Thereafter, the aforesaid team of police officials brought the accused
Hand
to the
of the accused and of the accused respectively.
Thereafter, the aforesaid team of
Photographs of who?
Accused, hands of the accused.
Hand of the accused and the deceased. Of what?
no, thereafter the aforesaid police team brought the accused
No,
to
no,
the
please read Exhibit 13 and 14 are the
Exhibit 13 and 14 are the two photographs of the hand of the accused and
of the hands of the accused
of the
and
accused respectively.
and of the,
These are, I think, typographical error.
what should it be?
Hang on, because the photograph
Hand of
have been
the
accused
accused and the
And the
accused. And the
and the
And
accused
of the accused.
and of the accused
Acha, and of the
There,
accused.
page
And the-
54 and
respectively.
55.
Yes.
Thereafter, the aforesaid team of police officials brought the accused to the Guwahati, took him to the MMC hospital, where his medical examination and treatment was done. And thereafter, the accused was brought to Nunmati police station. At the Nunmati police station, I again recorded the statement of the accused. Thereafter, the accused was taken to the place of occurrence, where the witnesses at the place of identifies him as the same person who was seen at the time of incident. I had collected the medical examination report of the accused from the MMC hospital, which I identify as Exhibit 7. After the accused was produced before the learned judicial magistrate and prayed for drawing blood samples of the accused, my lord, item 24 of the DFSL. After the accused was produced before the learned judicial magistrate and prayer for drawing blood sample of the accused for the purpose of matching the same with the samples collected from the crime scene at Setina was made, and the learned judicial magistrate by order dated 28/12/2010 allowed the said prayer, and accordingly blood samples of the accused was drawn by the jail doctor. Exhibit 15 is the order of 28/12/2010 passed in ZR case number so and so corresponding to Nunmati police station case number 487/2010. After the jail doctor handed over the blood samples of the accused, the same along with other articles contained blood stain recovery from the place of occurrence as well as from the possession of the accused were sent to the forensic science laboratory by exhibit number 16 pursuant to memo number so and so, where exhibit 16(1) is my signature. The said exhibit were received by forensic science laboratory hide exhibit number 17. Exhibit 18 is the official trace memo. All these are not relevant, my lord. But one thing is there, the statement of the two witnesses, namely Srimati Meenakshi Borgohain and Srimati Omiya Saikia, were got recorded under 164 of the Code of Criminal Procedure Code. These are the two witnesses whose 164 statement has been recorded. Now I am coming to, my lord, page 61. I am starting from material exhibit 1. Page 61. Material exhibit 1 are the knife and the scissors which were found on the chair near the dead body at the place of occurrence. Material exhibit 2 are the 3 mobile handset, SIM card, and 2 mobile phone batteries seized by exhibit 4 from the custody of the accused. Material exhibit 3 are the one handset, one tablecloth, two handkerchief, one gamusa, and one CD. These are the facts. Now, my lord, may kindly come to page 62, which is of great relevance to this case. SI of police, Honeshwar Das, recovered a mobile handset from the possession of the accused 1 month of the incident. Now, my lord, what has been stated by the IO in this particular part of his testimony, that the mobile phone of the accused person has been seized from him after 1 month of the incident. Had it been seized after 1 month of the incident, where is the seizures list giving effect to this seizure of his mobile phone? And IO himself established by his own testimony that other mobile that allegedly said to have been seized from the
Which mobile handset is this? We don't know.
No, my lord. But here, my lord, may kindly see the testimony of IO in page 62. SI police Honeshwar Das recovered a mobile handset from the possession of the accused
Yes.
after 1 month of the incident. After 1 month of the incident, SI Honeshwar Das has expired. So, man who allegedly, because my lord may kindly come
No.
to seizure list.
So this mobile handset relates to what? To the Samsung mobile, you mean?
No, my lord.
Then-
The Samsung mobile belongs to the victim.
Correct.
The other mobiles, those have been seized from the custody of the police, and the police who has seized, he has already expired. Now I'm going further, my lord. I have collected the CDR of the mobile, which was recovered by SI Honeshwar Das from the possession of the accused. How can CDR of a mobile can be collected from the possession of the accused, my lord? Because all detailed record is something that has to be.
I think these are translated versions.
No, these are not translated version, my lord.
I don't know.
Because these statements were being recorded, my lord, in English.
It is in
So
English.
it may not be clearly visible. That is why, my lord, this has been separately been typed out.
Please carry on.
My lord, I'm repeating. I have collected the CDR of the mobile, which was recovered by SI Dhanushar from the possession of the accused, which is highly improbable, absurd, and cannot be taken into consideration, my lord. Exhibit 21 is the CDR of the mobile phone number recovered from the accused. After considering the material collected during investigation, I have submitted the charge sheet against the accused 448-302-388 of IPC, so and so. Now, my lord, I am coming to page 63. This is the cross that has been done on the IO. I recorded the statement of Meenakshi Borua and Omyo Soikia. Exhibit 4, the seizure list was prepared by SI Honeshwar Das in the house of the accused father-in-law. SI Honeshwar Das has already died. My lord, this part is very significant. While making the statement before me, witness Omyo Soikia did not state that she had noticed as to who had passed through the window. So, the contradiction that I have already pointed out regarding PwC has been confirmed
She had-
by the IO.
Who had passed? What do you mean passed? No one can pass through a window.
No, nobody has passed through. My lord. Let us not get into literal, but what this witness tried to mean and say that before him, it is not stated by the PwC that she was watching through the window who has gone out. It is not a fact that I did not conduct the investigation properly. Right. So, out and out, this is a proof contradiction that has been made. Well, PW 21 is Sadek Ali. I'm not very much relying on this witness, so I'm skipping. But he is again the witness who has been declared hostile, my lord. And this is the witness that has been cross-examined by the prosecution itself, which witness it is made. Now I am coming to page 67, my lord, the deposition of the PW 22. Because he was an officer in charge of the police station. My lord, his testimony bears some relevance to this case. He again said on 10/12, the date is absolutely correct, my lord. On 22/12/2010, I was working as officer in charge of a police station. On that day, at about 8:30 p.m., Inspector of Police Someshwar Datta, that means the PW4, who was a resident of Narengi Housing Colony, informed over phone that some miscreant, some unknown miscreant killed one Roman Borwa, who was also a resident of that colony. After receiving the information from Someshwar Datta, I opened ZD entry number 949 dated 22/12/2010 and moved to the place of occurrence along with Deputy Superintendent of Police Sanmari, SI Akbar Ali, Nunmati SI, Bura Guhai, A. Bura Guhai, and M. Soikia with staff of the Nunmati. Now, my lord, the point here to be noted regarding this testimony of this witness, he has stated that on that day at about 8:30 p.m., he has received the information that the deceased Rumi Burwa has died. And why am I this pointing out, my lord? Because PW5 has categorically stated that till 6:30, the deceased Rumi Burwa was with her. So, by the conjoint reading of PW5 and PW22, it appears that till 6:30, the deceased Rumi Burwa was very much alive. So, information has been lost to the police station at around 8:30 p.m. Otherwise, it is highly improbable if somebody gets murdered at 3:30 or in between 4, and immediately after the incident, it was acknowledged to the police station. But why there is a gap of so much delay? Incident has happened at 4 p.m. and police has received the information at 8:30. Now, my lord, from defense side, 2 witnesses also examined.
Just a minute.
Yes, my lord.
Where is the arrest memo?
Arrest memo I could not find from the Harry, my lord, paper book.
Okay, we'll take it up at 2.
Can it be done tomorrow?
Will be tomorrow then?
We've got one judgment to announce. At tomorrow?
Because, my lord, this matter has come very spontaneously today. A witness has come in the session court, my lord.
Witness has come at sessions court.
Session court. And my lord, if this matter has been fixed on some convenient day, I could have completed at one go. But today, my lord, I am requesting to accommodate me. Kindly, my lord, for today only, my lord. If your lordship insists too much, then can we resume at 2:30? Tomorrow perhaps going to be more convenient. It is up to my lord. I'm not facing anything otherwise.
Okay, Mr.
B. Dekaman.
B. Deka. Then counsel for the present praise for adjournment. As he got some personal decision. So, Miss B. Buyan, additional PP. Also praise for time. Is it? Are you praying for time?
I'll do my part tomorrow, Lordship. Because he has raised so many points.
I doubt we'll be able to restore.
Tomorrow is not a hearing. You can take the first part of it.
Tomorrow there is some matter.
Monday, when we Monday. Monday, okay.
Yeah.
Monday to Monday to
Monday.
We'll have tomorrow. This is the matter tomorrow.
Deeply obliged, my lord.